All right, so we're talking about selective incorporation, and I think the best way to do so is to read the definition, get comfortable with the fact that we won't understand the definition, and then go way back in history to a time before selective incorporation, and then talk about what changed and led to selective incorporation, and then we will understand what selective incorporation is. So that's the process. So have no fear when we read this definition and it doesn't make much sense, because we're working up to an understanding of this definition. That's the plan. Okay, so selective incorporation is the process through which the Supreme Court applies fundamental rights in the Bill of Rights to the states on a case-by-case basis. All right, let that just sit in your brain, and then let's back up to a time before there was selective incorporation, and then we'll talk about why it started and then exactly what it is. Let's take a look at a Supreme Court case called Barron v. Baltimore, which is from 1833, I believe. Let me scroll on up. Can you see these court cases with a quick nod? Can you see a PDF of court cases? No? Hey, people told me in the last class that you could. Let me stop sharing and make sure you can. Yes? Okay, thank you. All right, so Barron v. Baltimore, 1833. This is pre-selective incorporation. This is not a required court case. You do not have to memorize the background details of Barron v. Baltimore. They're kind of silly, actually, not to diminish what happened to poor Barron here. But we need to understand how this is a reflection of pre-selective incorporation. That's it. So let's not get too caught up in the details. All right, so way back in the early 1800s, there was a man named John Barron, and he owned a wharf in Baltimore where he would charge people money to park their boats. And that's how he made a living. That was his job. He owned a wharf, you paid him money to park your boats. Well, as the city of Baltimore developed, it changed the way that water ran off, and it pulled a lot of silt into his wharf, and it lowered the water level. And now boats could not park in his wharf. And that was very unfortunate because that's how he made a living, as the owner of this wharf. So John Barron wanted to argue that the city of Baltimore had violated his Fifth Amendment rights regarding something called eminent domain. And here's where I'll ask you just to not get too caught up in the details. Basically, in the Fifth Amendment, it talks about how if the government's going to take your property, you have to be fairly compensated. So let's not get too far off on a tangent, but if the government wants to build a highway right through your childhood home, you can fight that in the courts for quite a while. But if they fairly compensate you for your property, they can take your home to build a highway. Now, don't let that keep you up at night. It's unlikely to happen. But protections from stuff like that and insurance that you are fairly compensated, is discussed in the Fifth Amendment of the Constitution. So what Barron is arguing here is that you've taken my property, you've taken my wharf, you've taken my ability to make money, and I have not been fairly compensated. It goes all the way to the Supreme Court. Let's listen to what the Supreme Court said. In a unanimous decision, the court found that the limitations on government articulated in the Fifth Amendment were specifically intended to limit the powers of the national government. So the court said the provisions of the Bill of Rights were written to protect you from actions of the national government. The Bill of Rights was not intended to protect you from state or local government actions. And they basically told Barron that the Fifth Amendment didn't apply at all in this case because he had an issue with the city of Baltimore. And according to the Supreme Court, the Bill of Rights protects you from actions of the national government. So that is the stance pre-selective incorporation. Let's take a look at what changed. What changed is the ratification of the 14th Amendment. The 14th Amendment is part of a group of amendments that are collectively known as the Civil War Amendments. They were passed in fairly quick succession right after the Civil War. And the 13th Amendment ended slavery. The 14th Amendment's original intention was to give citizenship to newly freed African Americans, and the 15th Amendment gave voting rights to African American males. The language of the 14th Amendment, with its original intention of giving citizenship and ensuring states recognize the citizenship of African Americans, has gone on to protect so many different rights over the years. I guarantee there are whole college courses that do nothing but analyze the 14th Amendment. It is that cool and that important. So let's take a look at the language of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And now here's where the language gets extra important for our purposes today. No state shall make or enforce any law which shall abridge the privileges or immunities of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its own jurisdiction the equal protection of the laws. So the 14th Amendment very concisely says no state shall infringe upon the rights that I have listed here. Privileges and immunities is originally discussed in Article 4 of the Constitution, and it basically means that if you have one right in one state, that right needs to be recognized by other states. It's why your driver's license works in Ohio. It's why if you get married in Hawaii and then go back to your house in Wyoming, you're still married. So no state shall infringe upon your privileges and immunities rights. No state shall infringe upon your due process of law rights. Due process of law means that you have to follow the proper judicial procedures before you would take away anybody's life, liberty, or property. So having a lawyer provided to you if you can't afford one, a jury trial, not having to self-incriminate. Those are all examples of your due process rights. And then again, it says no state shall infringe upon your equal protection rights. And our equal protection rights means that the law should apply to all of us equally. There should not be unconstitutional distinctions in the law based on race or gender or age, and we'll talk more about that in our chapter on civil rights. So what changed after Barron v. Baltimore in the Supreme Court's interpretation of how the Bill of Rights works is the language of the 14th Amendment. So now this language that says no state shall infringe upon these rights is going to be used when ruling on various court cases. So let me toggle back to our court cases. Okay. And let's take a look at an example of a required court case that selectively incorporates one of the provisions of the Bill of Rights to the states. The case is Gideon v. Wainwright. We are going to talk about this case multiple times throughout the year because it's a good example of selective incorporation. It's also a good example of something called in forma pauperis, and it's a good example of your Sixth Amendment rights and your due process rights. So this isn't the last time that we're going to talk about Gideon, but let's talk about it in the context of selective incorporation today. All right, so Clarence Earl Gideon was charged with felony theft. He had a bad criminal track record, a difficult life. He had dropped out of school in middle school. And in this particular case, he was accused of breaking into a pool hall and stealing like $5 worth of snacks. So he is put on trial in the state of Florida. He asks for an attorney because he cannot afford one. And the state of Florida said, we will only give an indigent defendant, meaning someone that cannot afford an attorney, if the death penalty is on the line. And thankfully, the death penalty was not on the line for a guy that stole $5 worth of snacks. So he was not given an attorney. He defended himself. He lost, and he was sentenced to jail. While he was in jail, he did all sorts of research in the library. He writes a letter to the Supreme Court. He gets the Supreme Court to hear his case in forma pauperis for free. We'll talk more about that a different day. And here's what the Supreme Court was questioning. Does the Sixth Amendment right to counsel in criminal cases extend to felony defendants in state courts? And here's what the court said. In a unanimous opinion, the court held that it was consistent with the Constitution to require state courts to appoint attorneys for defendants who could not afford to retain counsel on their own. The court reasoned that the Sixth Amendment's guarantee of counsel is a fundamental and essential right made obligatory upon the states by the 14th Amendment. So Gideon v. Wainwright is the Supreme Court case that selectively incorporated your Sixth Amendment right to counsel to the states. So here are some things we should notice about selective incorporation. It is a process that has to occur. It is using a Supreme Court case to apply provisions of the Bill of Rights to the states. Something else we should notice is it's not one amendment at a time, a big sweeping application of one amendment. It's one tiny little provision at a time. In this case, the Sixth Amendment provision to a right to an attorney. So because of the language of the 14th Amendment, because the 14th Amendment says no state shall infringe upon your due process rights, your Sixth Amendment right to a counsel applies to the states. What selective incorporation questions do you have? We're not done talking about it, but let's pause here. Sometimes I like to ask this question to gauge people's understanding of selective incorporation. The Third Amendment has never been selectively incorporated to the states. Why not? What's the Third Amendment? We're pretty lucky it's an often forgotten one. You don't have to quarter troops in your home. Okay, why has that never been selectively incorporated?
Because it's never been used in a court case.
Thank you, exactly, because selective incorporation is a process. It hasn't been called into question through a Supreme Court case, thank goodness. And so it hasn't been through the process of selective incorporation. All right, let's take a look at another required Supreme Court case that worked to selectively incorporate a provision of the Bill of Rights to the states. I think we'll be pretty surprised by this one because McDonald v. Chicago was ruled on by the Supreme Court in 2010. So we tend to think this argument we're about to take a look at is as old as time, but selective incorporation of this provision of the Bill of Rights happened in 2010. So McDonald v. Chicago is a required court case. I think in order to understand McDonald v. Chicago, we have to quickly talk about an earlier case called D.C. v. Heller, which is not a required case, but again, I think helps us to understand McDonald v. Chicago. So basically, the District of Columbia, which is in a unique situation because it's not a state, and it has its own mayor, but is also has a lot of control by the federal government. The District of Columbia created a law that basically said you had to leave your handgun at home, disassembled, and with a trigger lock on. So it was, you can feel about it however you'd like. It was essentially meant to prevent handguns from being out and about at all in the District of Columbia, at home, disassembled, locked in a box. So the constitutionality of that was called into question, and the Supreme Court said that that law was unconstitutional. And the justification that they gave, you can certainly read about in this summary if you'd like. People have a lot of different opinions as to the justification they gave because there was a lot of talk about the exact wording of the Second Amendment and usage of the word militia. But D.C. v. Heller was considered a big victory for pro-Second Amendment advocates, gun right advocates. So on the heels of D.C. v. Heller, gun right advocates decided that they were going to instigate a lawsuit questioning Chicago's handgun law. They had a big victory with Heller, and so they're going to ride that wave of success and challenge another law, and in this case, Chicago's handgun law. So the question before the court became in McDonald v. Chicago, does the Second Amendment apply to the states? Because now we're talking about Chicago, Illinois. We're not talking about Washington, D.C., which is this weird entity in and of itself now. We're talking about Chicago, Illinois. Does the Second Amendment apply to the states? because it is incorporated by the 14th Amendment's privileges and immunities or due process clauses and thereby made applicable to the states. So the big question in McDonald v. Chicago, does the Second Amendment apply to the states? Should it be selectively incorporated to the states? And the Supreme Court said that the 14th Amendment makes the Second Amendment right to keep and bear arms for the purpose of self-defense applicable to the states. So McDonald v. Chicago is one of our required court cases, and it's important to note because of what it says about the Second Amendment and because it is the court case that selectively incorporates the Second Amendment to the states. Questions about McDonald v. Chicago and selective incorporation?